Okay, so just to clarify, this the Attorney General, who actually appeared against Parliament on behalf of the defendants, where the Sergeant of Arms, acting on behalf of Parliament, came into someone's house and stayed for a long time when they only had the authority. They're going by what was actually on the warrant. The warrant gave them authority only to go in and apprehend the persons. So the Attorney General was basically saying that it didn't authorise them to basically, just, hang around in their house or whatever. It was actually what was authorised on it. They actually got done for trespass. But also, the verdict proceeded entirely upon the grounds of the defendants having exceeded their authority of what it said, but without any reference to the jurisdiction of the House of Commons. But clearly, if it was a warrant, if it says though here, it says the House of Commons, which their warrant from the House of Commons did not authorise them to, just loiter around in the house. It only authorised them to break in and apprehend the person. Well, it says that, and without any reference to the jurisdiction of the House of Commons. Well, if the warrant was issued from the House of Commons, then that surely, if the warrant is from the House of Commons, then why would you use no reference to the jurisdiction of Commons when it's on the warrant, right? Now that raises questions about when you write a petition and what you're petitioning for, what you're asking for, and what you're saying you're required to do in the petition. If it's an investigation, you need to investigate something. This is the thing to do with getting the public to sign it, and the oath of the petition and the writ of the petition and the power of the signatures on the petition, at least, the consent of your peers, going back to Magna Carta, the consent you're making an official legal writ using the right to petition Parliament. Now, some people might say, well, can Parliament authorise a warrant or a subpoena for you to go, enter or go somewhere to get something? Or can you ask Parliament to go somewhere or get something? There's, at least for prosecutability, because it's the right of the subjects to petition the king, and all prosecutions and commitments for petitioning are illegal. Now, the thing is, if you write out a petition and write out what you need to do and what you're doing, right, then, and people have signed it, then surely they, like a local court, and a jury, the signatories are consenting to, action that's required. This is where we got to now with sort of Stop ULEZ, with all these people supporting these petitions, against the cameras, and people kind of like covering the cameras up, or some people breaking them down. What can and can't you do without the authorization of Parliament? Well, at least for being liable to be prosecuted, I'm quite certain that the right to petition protects you from being prosecuted as long as the things that you're doing fall within what is required for the petition, which is, about drafting it and writing it down. Now, if you were doing it in writing and sending it into Parliament, or like a very professional casework thing, then that would be all right. But the thing is that on the Parliament website, when you do official ones on the internet and submit them and have them live on the Parliament website, they're restricting how many words you can write, or how detailed evidence you can put. And even they don't like you putting links on there unless it's to another Parliament website, even though you're getting the public to look at the evidence and make a decision and so forth, whether they want to sign it and support it. And Parliament are rejecting a lot of them as if they've got, the right to. But this is you've got the right to collect the signatures. That's the thing. And what they're doing is you're collecting, you're putting your own signature on it, and you can collect up till 20. But then they're refusing to publish some of them, so they're kind of letting you do it. But they're saying to get it debated in Parliament, you need 100,000 signatures. and they're not letting everyone collect 100,000. So I don't think that it's a lawful process, the online petition website, and they're definitely not offering any support or anything. So if they're not offering any support through, their own warrants and subpoena powers which they've got, then at least you must be covered, at least for criminal liability, But that's not to say that, this sergeant at Mace was challenged for, being in someone's house for too long. I think that, when there's people like Gil Bradbrook breaking windows and so forth, like the Department of Transport window, or if it's someone's own house or a bank or something, it does raise the question, if people have signed that petition and if it's under the jurisdiction of Parliament, maybe the right to petition does protect them from being prosecuted, but maybe those private individuals or businesses can take them to civil court for civil actions, just like apparently you can claim civil actions against members of Parliament in between sessions. But the thing is, does it mean all commitments to civil actions as well? The thing with the Department of Transport window is that it was insured. So if they claimed civil case against Gil Bradbrook for costs or money, it kind of like evades the point of having insurance, unless they wanted to claim like the surcharge from her or whatever. But as for criminal liability, maybe depending on how they've written their campaign and petition writ, but apparently all those Extinction Rebellion things are all, everything that they do is put on their websites and declared and subscribed to by many people. That's the thing. Like when you get onto the Tumultuous Petitioning Act, like where it says like public remonstrations, and people can, there's not just signing by hand. People can consent to it in other ways, verbally or by other agreement other than written down. But anyway, I'll carry on reading this and see where I get with it. But it seems like they're going by the actual warrant and the writ of Parliament when it comes down to this action against this sergeant at Mace breaking into their houses and just loitering around for too long. The Attorney General challenged them. It's quite interesting, the Attorney General actually challenging the government for once. Our current Attorney General seems to be on the side of Parliament all the time and acting on behalf of Parliament against persons rather than acting in these persons' defence. Like, why isn't the Attorney General on the side of Extinction Rebellion or on the side of Just Stop Oil, rather than on acting the government side? This is the thing. You actually, in that situation with the Attorney General acting on behalf of these persons against this, these sergeant at arms, they were challenging the government with the Attorney General. The thing with the Trudy Warner cases is that the Attorney General was acting on behalf of the government, challenging the petitioner, not acting on behalf of the petitioner, the Attorney General challenging the government on their rights, being infringed. And in fact, the whole point of the Trudy Warner cases is that a lot of those Extinction Rebellion cases really maybe shouldn't have been prosecuted against for criminal liability. They might have been able to have civil actions against them, but, is it covered by insurance? This is the thing. But I'm going to get onto the section, and actually, this book has got a section on petitioning, which I'm looking forward to reading, and it's actually, compared to this section, a lot shorter. It only looks like it's about 10 or 20 pages, or even maybe less than 10 pages. So this is where I am at the moment. So if Sergeant at Mace has got the same privileges as Parliament, but they still had an action against them for, not doing what it said on the writ or warrant, the thing is that is Lord Hanningfield doing what it says on the expenses rules? And there are some rules, but maybe they could have suspended them, but they didn't. And the thing is, when when Jeremy Johnson KC writes his paper, Observations on behalf of the Lord's authorities, he's just making observations, and then half of it's saying that, there's nothing reason why you shouldn't intervene, but then he says, things might or possibly touch upon Parliament. It's not actually a warrant from Parliament to intervene in the proceedings or actually declare it under the House or say that the court has overstepped its mark or not, or anything like that. It's actually it's kind of all out there, and it's all very kind of superficial, probably maybe a might or may or could, rather than like, this is a warrant for this, or you have done that, or we've suspended the rules for this, or so surely Hanningfield can be challenged of whether he did or did not, do something lawful or not. If that Sergeant of Mace is acting on behalf of Parliament and he broke a certain rule or not. And even so, the privilege is meant to protect them from actually going to prison, so they can still attend and go to Parliament, even if they have actions in between sessions. So it really, I'm still at this stage, I'm still questioning Johnson's actions. And then there's all the legislation as well that claim that, they can be prosecuted. So